Hello, Patty Jo here, and we are on day 2 of the Darrell Brooks trial. Just let's see where this is taking us. Again, we are doing the Law and Crime stream. Okay. I have not. I think this is going to be like end of day 1, really, actually. Let's see what Darrell has to say today.
We are on the record calling State versus Brooks, 21 CF 1848. I have the state appearing by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and I have the defendant Darrell Brooks appearing in person. I have the jurors coming in a little bit later today, but they usually come early, so I'm not sure if they're here. But I did want to make sure and ask if there's anything the parties wished me to address this morning. I don't believe there's been any new filings. I haven't seen any, but I did want to ask.
From the state, we would just like to make a record with regard to the concern Mr. Brooks had yesterday about the juror that he believed he recognized from his initial appearance that may have made some type of hand gesture to him. I did not, unfortunately, write down the juror number. I know what the juror looks like, but I couldn't associate it on my chart. Do you recall the juror number?
No, he didn't give one.
I'd be guessing. I think I know what it is, but
okay.
I don't want to be incorrect on that. But we can have the civilian bailiff provide us with that information.
I don't know if we want to do have that juror come out just to confirm. I know that the juror told the civilian bailiff who informed the court. Our concern is we certainly don't want Mr. Brooks to keep raising issues with regard to specific jurors, and we start using those alternates up. So I guess I'd prefer to be on the record that juror was not at the initial appearance. I know that the three of us were at the initial appearance. There was an older woman who did, I ended up talking to her during the proceeding. She was not the juror that was described yesterday or that I saw yesterday with the clothes that Mr. Brooks indicated she was wearing. So I just really would like that to be put on the record that juror, in fact, was not at the initial appearance, and have her come in, provide her name, and do that. Or the juror number, not her name, her juror.
So my understanding is that following what Mr. Brooks described happening at the initial appearance, there was a woman that one of the deputies spoke with and warned her. It's my understanding that woman may have been in the gallery on Monday and was warned about behavior then. I have issued an order. She is not allowed back in these proceedings because of that. I believe we know her identity, and I can tell you with certainty it is not our juror. So
nice try, Darrell.
And if there's anything else, any other requests, I don't think it's necessary to bring that juror out, given that record. But I will certainly do that if the state feels, or Mr. Brooks, that that's important for their understanding or confirmation at this point.
Yeah, and I think what would be important is to note if her pool number is the first 41. Mr. Brooks actually was in court on day 1 of jury selection, I know for a fact. I'm looking at my notes, it's unclear to me if he was present at any time in day 2 of jury selection. I know he was in day 1. So his claim that he was unable to see the juror at the time, obviously if it's a juror from day 1,
it's actually fair
to see her because he was in court with her. So that would also be something, I guess, if we could establish that she was part of the first 41, then I think the record is clear that the defendant was in court when the first 41 were brought out, and therefore he could have objected at that time.
I will get confirmation of the number, and we'll go from there as well. Any requests as relates to that, Mr. Brooks?
Before I get to that whole issue, Your Honor, if I may, I would like to state for the record and would like the record to reflect that I personally don't identify by that name. I am here as a third-party intervener in that matter, appearing as an authorized representative for my client. I accept for value, in return for value, all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
Okay, so he says this at the beginning of every session, really, not just every day. And this is a sovereign citizen, to my understanding, whole rhetoric. I looked up some of these things. Some of them refer to civil litigation, not criminal. Except for value, return for value is a way to say that to keep him separate. I don't identify as that name. He's calling out that is some sort of straw man situation, that they say that the all caps name that's on your social security card or on your birth certificate is not the name that you were given. It is a straw man that is developed by the government and so forth. And he doesn't really subscribe to all of this. And I had a commenter, I'm not sure if they were a subscriber or not, who mentioned that he got this information. Now, a lot of this information comes out of prison, but he got this information from his mother's boyfriend. Now, I don't know. I didn't look any of it up yet. But I'd like to look into it to see if that's where he's got it. But he very much cherry picks this information, because people who really subscribe to this line of reasoning, they wouldn't have talked to the police. They wouldn't have gotten down on the ground. They would have fought tooth and nail for, I'm not part of this, and you don't have jurisdiction. It would have been so much more of a different situation. He definitely subscribes to the United States justice system as it stands, and somebody's feeding him this information. So this is and all of this rhetoric, all of this, it has been debunked, is my understanding, from seeing things online and watching some of the attorney channels and things like that. Bruce Rivers and others that just say that it's completely void of any valid legal argument. So there we go. We'll have to suffer through that with every start of everything.
Your statements are noted for the record, sir. All right. As to the issue of the juror.
As far as the issue of the juror, I was maybe briefly present when the first wave of jurors were brought in. I didn't recall really being in here long enough to really get a look at the jurors coming in, because I was removed at that
Maybe
time.
We should go back
Actually,
to that.
Either they were coming in or shortly after they were brought in, I was removed. I definitely was not present for the second and third wave. I was in the other courtroom, so I can't see the jurors from the other courtroom on the monitor. So it wouldn't possibly be that I would have seen the juror that I was referring to yesterday.
Understanding that may very well be true. My recollection is you were removed pretty quickly due to an interruption early on. I don't have my notes in front of me as to when you were brought in or not. But I am advising you that I was able to confirm with others, including law enforcement, that the juror that you suspected was the woman who made an inappropriate gesture toward you at the initial appearance. They are not the same individuals. I've been able to confirm that. I know the identity of the woman who did what you said, and it is not this juror.
Is there any way that I can be sure of that?
Yeah, she just said it.
Do you want to have juror, I think it might be 41, I don't want to guess, but I can bring that juror out when the jurors get here, and we can have her under oath testify that she was not at your initial appearance or any of the proceedings in this case.
That would
I'm
Which
able
was
to do that.
probably,
that would be helpful, Your Honor.
it was probably part of the whole preliminary picking of the jury. I remember when I was picked as a juror, because I was a victim of violence that was not, that the person was not held any, that was caught but not held any responsible at all, that was just let loose by the system, that they questioned me very thoroughly beyond the written and the, what you're questioned in the jury box, by both parties. They took me aside, and the judge actually asked me several questions about, did I have any ill feelings towards the defense or prosecution because of that, and specifically the prosecution, because they didn't prosecute this person. And I was with the fire department, so it would have been a felony charge, and it was because it got very political in my case, and the mayor got involved. There was it just ran in and derailed any kind of justice that I would have seen out of the situation. And I guess my answer was, I repeated twice to two different questions, was, I know that the state's attorney did her best. That's what I know. Well, did you think you got a fair and just outcome? And I said, I know the state's attorney did her best. So do I think I got a fair outcome? No, I don't. But I know that wasn't because of, I know that once she questioned me, she listened to me. She assumed that I was just going to let it go. And then when she questioned and she realized it wasn't that way, she definitely brought everything forward that she could. And that was that. It just didn't go fairly for me. But this whole thing, this is another tactic, in my opinion.
All right. Can we check to see where they're at?
Because all of that would have been questioned.
And so to have that juror brought out. It's probably best we have a record of that juror number with specificity in any event.
The only concern I would have, obviously, we may know that there's one person at initial appearance who made a hand gesture. I just wanted on the record that if there was a second person, it's not the juror that's impaneled in this case.
I'm not aware of another.
Nor am I.
So she's saying if he keeps bringing it up. This one's starting to look a little pale to me. She's worrying me a bit. She needs to go outside and get some sunshine. Been a lot of stress on these ladies and this gentleman.
I'm not interrupting.
Give me 1 second. The juror will be out momentarily. Go ahead, Mr. Brooks.
I would like to state for the record,
Who cares?
the prosecution seems to be saying this with firsthand knowledge.
You referring to the issue we're talking about right now?
Correct, Your Honor.
Is there a question with that, or I'm
that's
not
not a
understanding
question.
why you're raising that at this moment?
Well, I'm raising it because the prosecution said that, and they stated that they knew for a fact that this juror is not the juror that I'm speaking of.
I said that.
Well, the prosecution said it too, Your Honor.
I provided the information, said I've been able to confirm the identity of the person who made an inappropriate gesture to you at your initial appearance. And then based upon the informal questioning of the juror that you suspected was that, determined their, confirmed that she was not that individual, and then subsequent to confirming that with that informal information, I was able to do some additional questioning of law enforcement and others to determine the identity of that other person and confirm, in fact, that what you said happened, but it's not this juror. But we're going to bring that juror out just so you can, or I will, question her about that. So there's a very clear record that your concern and whether one of the jurors on this panel was at your initial appearance and made an inappropriate gesture can be put to bed once and for all, so that you're satisfied they are two different people, okay?
Thank you, Your Honor.
All right. Just can sit in the jury box. She's a juror. She's not she may be put under oath and questioned, but she's a juror, and so no one can film her or take her photograph. Go ahead. She can just sit in one of the spots in the jury box. Good morning. You can have a seat. I just want to put on the record, this is juror number 41, and you are not in trouble. We just have had an issue come up, and we wanted to make sure we all had accurate information. At any point in time, did you attend any of the proceedings in this matter regarding Mr. Brooks? Were you ever at the initial appearance for Mr. Brooks? All right. State have any follow-up based on that?
No, Your Honor.
Mr. Brooks, any follow-up based on what I've asked this witness, or what I've asked this juror, sorry.
No.
All right, thank you. Thank you so much.
So in other words, and
I'm going to wait till she's back.
how can he think that he doesn't make an impact? Now, I know she's not going to run back there and say, what happened or anything like that. They just had a couple of questions, and it would probably get dropped. But how can he think that he's, oh, okay. I was, it's obvious that she was being accused of something.
Out of the courtroom, because there's a hallway behind you.
He's just so
and then ask
slimy
the follow-up
to me.
Mr. Brooks, we brought out juror number 41. Was that the same juror that you initially suspected was someone who was at your initial appearance?
Yes, Your Honor.
All right. And again, she denied. She said she told us she wasn't there, and I trust that satisfies your inquiry into this issue.
I'm still a little leery, but
Okay.
I say that. I'm not interrupting, am I?
Go ahead.
I say that because I don't forget faces. I don't.
Okay.
All right,
That's
I
not a
understand what you're
legal
saying, that the
standing.
record is made clear, and I'll make a finding that juror number 41 was not at your initial appearance and is not the person who made an inappropriate gesture to you either at
So
or
I'm
following
leery.
that
Ugh.
hearing. All right, then any other issues from the state?
Yes, Judge, just briefly, if you, from yesterday's testimony, we'd like to move into evidence Exhibit 1, which was the map, Exhibit 3, which was the video played during Corey Runkle's testimony, and Exhibit 5, which is the photograph of Erica Patterson. They were all testified to yesterday.
Any objection? Mr. Brooks?
Yes, Your Honor. I guess it would be to the terms of relevancy.
Well, at least that's
There's been no testimony from Ms. Patterson, so I'm just curious to know the relevancy of that being made evidence at this point in time, because
it was identified.
what was said yesterday was that she would be testifying at some point. Would it not be better to have that admitted then if she decides to testify instead of right now when we're not even sure if she...
Because you really think she's not going to testify? You think you can still continue to bully her out of testifying? Darrell, I know I'm looking at the screen. I should be looking kind of like this. Darrell, do you really think that you can still bully her out of testifying? Like you, in the future, will bully your family out of testifying that you pointed a pew-pew and shot it at him. And that was his nephew. And yes, he did bully him out of that. I fully believe that.
He is going to testify.
Your objections are noted for the record. There was a proper foundation laid regarding each one of these exhibits. They also are relevant to the issues within this trial, and I'll admit exhibits 1, 3, and 5, and also advise the jury when they come back into court this morning.
Your Honor, I'm not interrupting, am I?
Hold on, I'm not
Yes, you're interrupting.
to you yet if there are any issues, any other issues from the state.
Yes, Your Honor, I would just like the record to indicate that I understand we did not follow up with this after the lunch break on the record, but it was my understanding that Mr. Brooks did receive the medical attention that he was seeking over the lunch hour. So I just wanted that on the record. And then
Okay, so what she's referring to is he had a small cut on his pinky, I believe, and on the other arm there was a bruise, which is hilarious when he's questioned about this, because he's going to say, yeah, they came and healed the bruise. I mean, he is just such a child. Oh my gosh.
finally, Your Honor, just a reminder to Mr. Brooks as to the other acts evidence. In line with his questioning of Corey Runkle yesterday, Erica Patterson will be testifying here this morning. The court issued a ruling as to the other acts evidence. The state strictly abided by that. Mr. Brooks came very close several times to opening the door to that testimony. We treaded very lightly on purpose to be respectful of the court's ruling, but the court warned him twice. Mr. Witschow even personally went over and warned Mr. Brooks during Ms. Runkle's testimony. And before we start another round of challenges, potentially during Ms. Patterson's testimony, we just wanted to make a record of that so that Mr. Brooks knows if he opens the door to that other act's testimony, it will come in. And I appreciate it.
Okay, so apparently during some of the preliminary hearings, some of the previous acts or crimes or even convictions of him being domestically abusive to Erica Patterson was excluded. So they can't question that. And that is why during Corey Runkle's testimony, she actually turned to the judge at one point and said, can I even answer that? Because what he was asking was, how did Eric, I believe the question was something like, did Erica Patterson ever tell you anything about the relationship between Darrell Brooks and herself? And yes, and what was that she said might not have been a question that he should have asked, because that would have, the state can't ask it, but if he asks it, apparently it's fair game for everybody. And that will come up again and again and become very clear to us. And my understanding, the reason my understanding is this clear, and my attorney friends, because I'm not an attorney, can clarify it for me. Am I correct? I think I am correct. If he questions her, they can question about it all they want. And then all of those past acts can come in. And according to that other hearing, those are too prejudicial to him. It would be make it an unfair trial to him. So, interesting.
Raising that as well. Mr. Brooks, on the issue of medical attention, did you see the jail nurse or other medical personnel during the lunch hour yesterday?
And he's going to get so.
Yes, I did. I received a cleaning of my cut and a bandage.
Got a Band-Aid. Excellent.
All right, thank you.
Oh, I'm sorry.
I was
getting to the other parts of the injuries. They
Go ahead.
viewed the bruises.
They
that I
healed
have
the bruises.
on my arm and legs as well.
That's
know what's
totally
gonna happen behind
untrue.
that,
They
but
healed the
I
bruises.
was looked at.
What about what you did to all those people?
All right,
Never
thank
mind.
you. Does not appear to me that any of these injuries or interfering in any way with your ability to be here today and assist in your own defense.
So let's talk about how you're dressed.
Yeah, I'm just a little tender, just a little sore. So.
I'm tender.
All right. Mr. Brooks, do you understand what the state is referencing as it relates to the other act's evidence?
I do not understand.
Do you recall being in court at the end of August when the court addressed a number of motions, including a motion brought by the state to admit other acts?
And with all respect, Your Honor, this whole process is very, very new to me. So I'm trying to, I guess, stay within bounds of the questions that I'm allowed to ask. If I color outside the line, so to speak, it is not intentionally. Because I'm basically learning as I go.
Ask all
So
those
I'm going to
questions.
have my clerk print out the motion for other acts that was filed by the state, along with the response that was filed by your attorneys at that time, and further advise you the court did not grant the state's request to admit other acts as it relates to your conduct with Erica Patterson prior to November 21 of 2021. And your questions yesterday of Ms. Runkle could have opened the door to the court revisiting that issue. That's why the court stopped. It was interesting. Ms. Runkle clearly was advised not to talk about other acts. The state followed the requirement that they advise their witnesses about the court's order as it relates to other acts. And I believe I kind of paused twice and said, are you sure you want to answer that? I referenced generally some prior rulings so as not to alert the jury to anything more than that. And then at one point, Attorney Wichow also came over, muted your microphone. I don't know what was said, but my understanding is he basically kind of gave you the same caution. There's a ruling, something to that effect. And I know you didn't proceed with the questions that you had originally attempted to ask this witness. So it's very clear what we're talking about. Again, I'm going to give you these filings so that you understand what I prohibited in this trial. And the record to reflect those filings are being provided. Madam Clerk, do you happen to have the document numbers for those? Sorry, I should. 170. Document 170. And 161. So documents 170 and 161 were provided to Mr. Brooks. So the only other thing I'll say on that, sir, is if you ask questions, I'm not going, that would open up the door potentially, or at least ask questions that call for answers that might fall within that order that I issued. You do that at your own peril, and you may open the door to the state bringing in other witnesses and other testimony about those issues. So I want you to be advised of that. You are correct that when the state made the request, I prohibited the state from introducing that evidence. So you're not incorrect when you say I didn't, when you kind of referenced about there's a difference between me prohibiting you and prohibiting the state. But from my perspective, the order that I issued was to your benefit. And so you can ask those questions. You're not prohibited, but then you potentially open the door to that information becoming
part of the record,
admissible in this case. So I want you to be advised of that.
May I quick, Your Honor?
Go ahead.
I'd just like to say that I accept for value in return for value these filings. I do believe that I have a little bit more clarity, if that helps.
Thank you for putting that on the record. Do you have any other issues you want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, the subject matter jurisdiction.
So the delay tactics.
And
Anything
also,
else?
Motion for finding a fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied by the court. I point you to the case of, I have my post-it note back. The Beneby decision at 654 F 3rd 753. All right. Anything else, sir?
I'm not interrupting, am I?
No, I'm asking you a question.
Just for the record, Your Honor, I would like the record to reflect, is that a judicial determination that you are making?
Yes.
Your Honor, Mr. Brooks, the record speaks for itself. I've made my decision. We're moving on.
Yes.
All right. With that, then, State have a witness available to be called.
We do. Would you also just make a record, Your Honor, this morning that Mr. Brooks does appear again in his
thank you. What he's wearing.
jail uniform, and that he was offered the ability to wear street clothes and declined that offer. Also, he does have appears to have all of his discovery materials at the table with him.
Yes, thank you. I should make a record of that as well. I didn't state at the outset Mr. Brooks is here in person and in custody. He once again has come to the courtroom in jail attire. I presume, Mr. Brooks, but please confirm for me, you were offered the opportunity to change into street clothes?
As I stated on the record yesterday, I'm waiting for the results of the COVID test that
That's
I
not
took.
a question. Nobody cares about
So
that.
until I get those results back, I would prefer to not wear street clothes at this time.
All right. Can you confirm for me, though, that you were provided an opportunity to change into them if you so chose?
And not to my knowledge.
Sir, I'm providing you with that opportunity right now. If you would like to change into your street clothes, into the suit and tie that you had previously, or any other street clothes, I would give you that opportunity. Did you hear me advise you of that just now?
I might consider it. Maybe I may have more information from the medical staff once we take a break, or maybe I'm anticipating. Well, actually, I anticipated that I would know before we even started court. So that.
Do you want me to have the bailiffs ask the CO if there's any new information that can be relayed to you before we bring the jury out?
That would be helpful, Your Honor.
Do you have any objection? I could email the jail administrator if you want, or I can just simply have the bailiffs do that.
Whichever works best for Your Honor.
All right, let's see. She's not going to give me information in an email, that much I know, but I could at least find out if there's new information. If there's new information, then it's going to have to be given to you directly. That may require you to be taken into the holding cell to be given that information, okay?
I'm okay with that.
Okay. Let me just continue that. Again, right now he's in the jail attire. We're going to give him an opportunity to see if there's any update regarding the testing that was done earlier this week. And until we at least get word whether there is new information or not, we'll not bring the jury out.
Okay, so this COVID test. There was a hearing prior to the first day. And in that hearing, he had made a motion to adjourn or to delay or somehow, I don't know what the exact word was, because he said that he had all these COVID symptoms and that he was complaining that he wasn't feeling well, fatigued, trouble with smell and taste, and there were some other symptoms that he was complaining about. And he thought that that would stop the whole trial. It was again, another tactic. So the jail, apparently, from what I understand from what I watched, they offered him the PCR test. The PCR test, as I know, as a person in the medical field, takes a couple days because PCR means that they repeat the DNA so that they can get enough of a sample. They take the sample, they repeat that sample, or in other words, make copies of that sample so that they have enough of the sample. This is very rudimentary. That's not exactly how it is. It's all microbiology level stuff. And they then take that and test it, and it's a test that it would with clarity say positive or negative. Now there are some arguments that some of our tests were not as accurate as they could have been, especially early on in COVID, but this is a year into this. I think this test there was also a rapid available at this time, which they did offer him. And then his arguments were, oh, well, why didn't they offer me the right one in the first place? And I already took one. And what's this second one? And like all this conspiracy stuff. And the rapid one takes just the same sample, the nasal sample, and will in 15 minutes give you a positive or negative. Is it as accurate? I don't know. I'm not a microbiologist. I'm thinking that it's accurate enough to have been put out on the market. But, have I done anything? I've done one PCR test at one point when I had a fever, which was negative. And I was a paramedic, so I was exposed to literally everybody, obviously. And with my medical problems, that compounds it. My doctors were very, cautious with me about whether or not, so every time I went in for a treatment or a new drug treatment or something like that, I was tested prior to that. I was tested with rapid and PCR at times just to be sure that they weren't giving me something that compromised my immune system when I could possibly have COVID. So, I've been exposed to these tests. These are not like invasive. Were they totally comfortable? No. But his response to this is ridiculous, and eventually he's not going to dress in his real clothes till he gets the results, because he's making a big deal out of this. So there you go. There's the recap.
I will make a record that Mr. Brooks does have the 3 boxes that have been referenced previously. I see the objection sign. I see the selected statutes that the court provided to him previously, and I see he has a number of papers in front of him. So he looks as if he's prepared to participate meaningfully today.
Wait, I'm not meaningfully.
Sure.
You didn't say anything about my Bible.
I did bring these boxes up. I have not had the time to go through everything in there. As you can see, it's a lot.
So?
That's putting it minimal. A lot. So I have not had the time to go through everything that's in there. I'm winging it, Your Honor.
Deputy Wittig, any new information? Yeah. All right. Well, can you provide that? Well, let me just do it. All right. The information that I have on whether there's new information is they don't have the results, but medical will be called again to check on that to see if anything new. Any new information is available, but as of right now, there's not. I also was advised that you were offered 3 times to have street closed by Officer Gabor.
So in other words, you're still a liar.
All right, then, Mr. Brooks, we don't have apparently new information. I intend to just continue then, okay?
Really quick.
Delaying some more.
To the decision of Your Honor for me to be removed from the proceedings over the last few days. That was used from the Illinois versus Allen, right?
Correct.
Okay.
I also had cited to a case that I believe is on point, although not binding on this court. I am persuaded by the reasoning in United States versus Jennings, found at 855 F Sup 1427, which is from 1994, from Pennsylvania. And as well as, sorry, just that one. That was affirmed by the Third Circuit in United States v. Jennings, 61 F. 3rd, 867. Third Circuit, 1995. So the first decision I referenced was a federal district court decision, and then the Third Circuit decision. Let me know if you need those citations again.
Does any one of those mention the being present through audio and visual?
Why would they? They're old.
Yes, audio.
Okay.
In other words, the
Would that be
defendant in that case, who also was a pro se defendant, was removed from the courtroom after he said he would continue disruptive conduct in the presence of prospective jurors, but he was able to continue to listen to proceedings through loudspeakers and transmit messages to the court, was barred, and what the court held is he was barred from the proceedings by his own conduct, not by the court, and the conviction in that case was affirmed. Do you want that citation again?
No, I'm not interrupting, am I?
No, go ahead.
I do represent myself pro per. I would like that stated for the record. Like the record to reflect
Is
that.
there a
not pro
difference?
se.
I don't think there's a difference.
The record will also reflect your choice of term to describe your appearance today.
I've briefly read Illinois versus Allen. It didn't say it didn't give any reference at all to him being present by audio or visual in that case.
Okay, I'm going to go back and read Illinois versus Allen, but my understanding is the case is from the 70s, which would make it contemporarily relevant. But my understanding also is that they leave the technology portion open to new technology being available. Audiovisual and connecting the two courtrooms is a recent technological availability by way of technology and by way of probably budget too. But he's trying to say because it doesn't say that exact thing in there, they can't use that. It just is dumb.
Whatsoever. It just strictly talks about the reasons that he was removed and the options that the judge had in that. One of them being that he could be bound and gagged.
One can only hope.
One of them being that he can be held in contempt.
We're not going to do that.
And removed from the courtroom while the trial would continue, but it did not say anything about being present visually or by audio.
Well, I appreciate you reading the case, sir, and providing that information. I'm well aware of what the case says. And as that case says, the Supreme Court talked about there would be no one formula for maintaining the appropriate.
She's going to say something here that is not a mistake, but she will regret, I anticipate.
Courtroom atmosphere, and no one formula will be best in all situations. But the Supreme Court said this: we think there are at least.
Okay, there is the verbiage that opens it up to what she says. So at least indicates that the people who made the ruling say these are that we're listing plus any others that could be applicable. Any reasonable person would interpret it that way.
3 constitutionally permissible ways for a trial judge to handle an obstreperous defendant like Alan, going through the 3 things that you identify. And my findings here are that there's a 4th way, and that's through the wonders of technology that weren't available in 1970 when that decision was authored. So I appreciate the notation
so in other words,
on the record.
At least gives her
you are here today, and I hope you stay here today. That's certainly my preference. You've demonstrated you're able to prepare, you're able to ask questions, you're able to articulate in a clear, coherent, cogent, and responsive way. And I'd like to bring the jury out, and that's what we're going to do next.
I'm interrupting real quick. I just want to say something very quick to that.
Very quick, sir.
I don't see that 4th way, Your Honor. Also, when
Mr.
they talk,
Brooks, my decision stands from previous.
There you go.
If you believe there's any error that I made, that is for you to address if there is a conviction and on appeal. But my decision stands, and the record speaks for itself.
May I put on record that I intend to appeal that
Sure.
judicial decision, Your Honor?
Understood. You may appeal as you deem appropriate.
Thank you.
All right, thank you. Let's bring the jury out.
All right.
I will ask everyone stand.
I'm going to take a break here because holy cow, that was painful. And 40 minutes. Okay. Thank you for joining me. Thank you. We've reached 100. I love doing this. I think it's really good for my soul to be able to sit down and at least have something to do, something to look at, even if this is a little bit on the old side. I think this is going to be a pinnacle case that we're always going to look back on for mental health, narcissism, behavior, where we are going. How did we raise a generation that has that coming out of them? The amount of evil that just permeates from him. Okay, so we're gonna leave it at that. Thank you for joining me. This is Patty Jo. Thank you very much.